Mulad 4 at the bottom.
We've seen it. We've seen it.
India is referred to as if it's a foreign country.
All right. Yes.
Mulad, therefore, I was
Will you
insisting
please allow
yesterday
me now, sir?
that his affidavit must say that I withdraw these statements. I do not
Mulad,
support terrorism. I do not support any separatist activity, and no citizen in this country can logically
We must have a
any
uniform
objection
affidavit for every
filing.
citizen to file this, Mulad.
Can I just
In
say
this
something,
court.
Manoj? That point 3 at page 6, they say pushing a separatist agenda. Filing a 370 petition in this court is pushing a separatist agenda.
I'm sorry.
I have a very strong objection to the government of India taking this.
I am sorry.
All of us are pushing a separatist agenda by being.
Please.
One second. One second.
No, I'll clarify.
One second.
Mulad, I
haven't-
Mr. Solicitor, please wait for a second. Mr. Shankarayan, I think this is unfortunate. Nobody can say that because a petition under 32 has been filed. Up to this point, nobody has said that the filing of a petition constitutes separatist agenda.
I have said.
We have
saying that.
Well, why this date is mentioned
One
even
second.
after filing he has.
the access, one second, access to our court for ventilating grievances of citizens within the framework of the Constitution is a constitutional right in itself. Anyone who accesses justice under Article 32 cannot be turned out on the ground that you are following this agenda or that agenda. On merits, which way any individual petition goes is for the court to separate the grain from the chaff.
May I clarify?
But I don't think, we have not, Mr. Shankarayan, we have not heard the government.
Saying this about us.
We have not
Only
heard
a
either.
minute, Mr.
One second,
Shankarayan.
Mr. Solicitor, 1 second. We'll put a lid on this now. Otherwise, this will go on endlessly.
Well, only give me-
1 second. We have not heard either the Attorney General of India, who is leading arguments for the Union of India, the Solicitor General, who has shouldered a large part of the burden, say that these petitions should be dismissed on the ground that they are separatist agenda. They have argued the matter on merits. It has been argued on constitutional terms. We have indicated that that's how we are going to resolve this issue. And I don't think that's been the main plank of either the solicitor, the attorney, or anybody who else who followed.
That's all I'm.
Sometimes
mentioning of
sometimes when individuals as interveners come before the court, we also as judges understand that
They are
there
petitioners. They are the lead petitioners.
there's an anguish which was
Solicitor
expressed,
is not the interview.
and that anguish which many of the interveners have expressed, we as judges know how to deal with that.
Give me a minute more. Give me a minute more. The date for 18th March is mentioned that petition is filed to show that even subsequent to the filing of the petition in May 2018, etc., my lord, this continued.
Mr. Solicitor, you have
Filing of a petition
Mr.
is
Solicitor,
not a
you have made your point. You have made your point, Mr. Solicitor. Mr.
Yes.
Sibal.
Mulad, I hope that sentiment applies to us also, because we have not made any submission other than on the law and the Constitution. Just as the other side has done it, Mulad, at least we have not made any submission outside of that, Mulad. And we want to carry on this debate, Mulad, through the Constitution, not through processes of this nature. Anyway, Mulad. Now, Mulad, yesterday your Lordships asked me a question about merger, how many mergers have taken place. So you have therefore the Chief Commissioner's provinces, you had the princes merging into the provinces, and you had these 5 states, all through merger agreements, no exception. Except Jammu and Kashmir, because that was not conceived in terms of 370 itself. And see if you.
Mr. Sibal, it was an action on its own, or it was something which was the government of India at that time ensured that it happened. Obviously, the government of India ensured that it happened.
There was no question on its own. Mulad. It would never happen like that. Some of them couldn't exist independently.
So, we have understood your argument on that. Can we move on?
Now let's look at PDF 379, because all those proclamations are different from the proclamation Kwe Jammu Kashmir, which is Mullad's 25th November 1950, before Mullad's the 26th January 1949.
The proclamations is the firman of the Nizam as well. The Nizam you find at page 377,
Yeah, but the language
23rd of November
but the language is
1949.
different.
This was certainly not voluntary.
Of course not. Of course not, Mulad. I agree. This is what I responded to my lord. But Mulad, the language is different from Jammu and Kashmir.
So, keeping you probably in J&K, keeping at that time the political environment, it was something different.
That's all that I'm saying, Mulad.
That's
My argument.
we have understood that argument.
Yes, and therefore it was incorporated in these terms in the Constitution, which was not done by anybody else. which only shows to you that merger was never contemplated except in terms of 370. All the others became through these proclamations part of these states and then became part of B states. All these states became part of B states. Jammu Kashmir were not. It was the only state excluded from Part B states.
But equally, the proclamation which Yuvraj executed, which you find at page 379,
Yes.
which we have seen earlier,
Yeah.
says that the entire relationship between Jammu and Kashmir and the Union of India will now be governed by the Constitution of India.
Correct.
And all previous understandings
Are gone.
are all superseded.
Absolutely. And see what the language is. The Constitution of India shortly to be adopted shall be insofar as it applicable to the state of Jammu and Kashmir, govern the constitutional relationship. So you go back to that. That is 1 and 370 only, Malat. Nothing more than that. I just wanted to show your Lordships, Malat, because your Lordships put me this question. I think it was a very significant Malat's query. And they all followed a uniform pattern of integration, other than Jammu Kashmir. And Malat, the white paper also says that the integration of states did not follow a uniform pattern in all cases. You will find that, Malat, at page PDF 46.
Because you have to deal with them differently. All the
Naturally.
I have understood that argument. Today the issue is not this. Today the issue is whether 370 was really a temporary thing and whether in terms of 370 it could have.
I am giving the historical background to show the difference and why he did not merge. Because in the meantime, many things had happened, including the matter going to the UN. This all happened prior to this, Malat. Therefore, the question of merger didn't arise. That's the point, Malat.
That has all been argued in your opening arguments.
No, I'm only giving the background to 370, Malat. I'm not arguing it. My Lord put it to me. I'm just giving the background, nothing more. I'm not arguing. I've argued 370, Malat. I'm not arguing, Malat.
Historical background also you are given in your opening argument.
No, not the merger, because my Lord put me the merger agreements. There's a difference between merger agreements in all other states at that time, that is the 552 states, and except for Jammu and Kashmir. That's all, brother. And they have argued merger. I did not argue. Anyway, be that as it may, Malat. Malat, if just one other thing, Malat, your Lordship put to me that, look, there is a silence here in the Constitution. Malat, I just want to answer that. And I'll Malat, read what I have to say on this, Malat, so that it's on the record. My first statement is integration was completed when the Constituent Assembly of Jammu and Kashmir completed its task and the Constitution of Jammu and Kashmir was adopted on 26th of January 1957. The governing structure comprising the Constitution of India and the Constitution of Jammu and Kashmir complement each other, and through the bridge of Article 370. The scheme operated without conflict for 70 years. This very scheme, there was never a conflict. By CO 48, a proviso was added to 368 too. That can't mean that the 370 was silent on the consequences. If it was silent, 368(2) proviso would never have been added. Next, there were no silences left to fill except the silence of the people of Jammu and Kashmir, who were never consulted and taken into confidence when issuing CO 272 and 273. That's the only silence that prevailed. Is also given effect through a bilateral process. Bilateralism is at the heart of the said process because you have to consult at least get agreements of at least half the members of the states. That too is a bilateral process. Nothing can happen outside there can't be a unilateral act of an executive, not even parliament. Consider this, Malas, what we're talking about, a unilateral act of the president acting on the aid and advice of council of ministers, not parliament. So, Malas, with respect, I say there is no silence. So that was, Malas, just our submission, Malas, on that issue. And then kindly have a look quickly at the Constitution of India for a minute, Malas. Now, if you see, Malas, I'm not going to read the language. Just want to ask your lordships to notice three things. One, there are entire Article 370 has 2 colons. The rest are all semicolons. And the 2 columns reside where, Malas? They reside in D. There's a colon after D. And there is a colon after 3. 370 sub-article 3.
Colon after D?
D, Malas, 37 1D. And colon after 370 sub-article 3. So you cannot exercise that power independent because it's integrated. The process is integrated, and it's only a process that we are talking about. We're not talking about powers here. 370 is only a process of integration. And Miller's Constitution Bench and Manohar mentions that. And we are dealing with the process adopted by the government of India consistent with this process of integration. We're not talking about anything else, Millers. There is no unilateral notification issued by the government of India, by the President on the aid and advice of the Council of Ministers that's before you. There is no unilateral declaration. And I'll assume for a moment, Millers, there is a silence. How will your Lordships, Millers, integrate that silence into 272 and 273? Because 272 and 273 deals with 370 sub-article 3 as it stands. You will still have to say whether 273, 272, 273 is consistent with the unilateral notification to be issued by the President, which is not there and which is not before you. It's not possible to match the two. It's not possible for you to state constitutionally, Millers, that 370 notification or under sub-article 3 will justify the action taken, which is 272 and 273, which has nothing to do with the notification. If you uphold 272 and 273, you will have to uphold it on its own terms, not on terms other than 270 sub-article 3 and the proviso, because that's what they have adopted. Even if you were to accept that argument, it's not possible for your Lordships, with the greatest respect to Millers, uphold the action under 272 and 273. And kindly see the absurdity of this. The absurdity is that when it comes to 371, B1 and 2, you have to consult, or you have to, the state has to concur. If it comes to 370, 1B, again you have to consult or concur. When it comes to 373, you can abrogate without consultation, without concurrence. How can that interpretation ever be accepted by a constitutional court? Means that you don't need consultation, you don't need concurrence. You can unilaterally do it. For everything else, you'll need that. That's a constitutional absurdity. For individual articles, you have to concur, but for the whole abrogation, you don't have to concur. Even for a law, you have to concur, Miller. This is, I give the greatest respect, Miller, at least take the text and the context, Miller, not a pretext.